Hey everybody, Todd Vandermeid back for another edition of Freedom Steel. We've got some breaking news today. Actually, it occurred last night with the Seventh Circuit issuing a stay in the Southern Illinois consolidated cases known as Barnett. More after the intro. All right, everybody, Todd Vandermeid back for another edition of Freedom Steel, former NRA contract lobbyist, Illinois gun law guru, the gun Santa, tactical Santa over on Reddit and everything. So let's get down to business here. So yesterday afternoon, the Seventh Circuit Court of Appeals acted upon the request for a stay from the state of Illinois in the Southern Illinois consolidated cases, which we collectively refer to as Barnett. So you have the NRA NSSF case, which is Barnett. You have the SAF case, which is Langley, I believe. Then you have Harrell, and then you have FFL Illinois, the case that I'm involved in. So with that, the order isn't terribly long. It's a little less than 2 pages. So I'm going to read you the order in its entirety, then we're going to cut it up. Defendants have appealed and they request a stay pending appeal. The plaintiffs have responded and defendants have replied. The parties also have filed memoranda addressing the problems created by the district court's noncompliance with Rules 58 and 65. Appellate jurisdiction exists, notwithstanding these errors, because it is plain that the district court is done with the case. Compliance with Rules 58 and 65 remain necessary, essential, if any litigant anticipates enforcing the decision through the contempt power, and we trust that the district court will enter appropriate orders promptly without the need for a formal remand by this court. Defendants' request for a stay rests largely on the fact that this court already has held that the laws in question survive motions seeking preliminary injunctions, Beavis v. Naperville. A decision at the preliminary injunction stage is not dispositive when the plaintiffs later seek permanent relief. Our opinion indicated some matters that needed further exploration, but the analysis in Beavis shows that the laws have enough support to remain in place pending the final resolution of plaintiff's suit. Every other court of appeals that has addressed the validity of similar litigation in the wake of New York State Rifle Association v. Bruin has come out the same way as Beavis. See Ocean State Tactical v. Rhode Island, Bianchi v. Brown, which is now Snope, Hansen v. Smith. The laws addressed by those decisions differ in some respects from the Illinois statute, yet the absence of support in other circuits for the district court's disposition lends strength to a conclusion that the Illinois statute should remain in force until the final appellate resolution. At least two other essentially identical suits are pending in other district courts within the Seventh Circuit. The three suits were addressed jointly in Beavis, and they must be resolved in the same way eventually. The state laws cannot be valid in some parts of Illinois and invalid in others. This does not necessarily imply that the three cases will again be consolidated on appeal. We are reluctant to delay disposition of this appeal indefinitely just because similar litigation is pending in other districts. Still, the only way to preserve the status quo statewide is to enter a stay in this suit. The judgment of the district court accordingly is stayed. The stay will remain in force until this court has issued its mandate. So there we are. So that is the Seventh Circuit. Now, things that we know. This was referred back, and we had a question whether or not we would draw a new panel, what panel we would draw, because in the previous panel, you had Easterbrook, Wood, and Brennan. Wood was the author of the opinion. Wood retired from the bench. She didn't take senior status or continue on. She retired. She is no longer a judge in the federal system. So we had that. And this order came out under cover of the panel, which lists Easterbrook as the lead judge now. Frivolous Frank is back again. Funny how he always seems to land on these big cases. We now have St. Eve, who is replacing Judge Wood, and you have Brennan back up there again, who voted in our favor the last time. Mark Smith over at Four Boxes Diner, who I have a lot of respect for, is holding on some hope that St. Eve will do the right thing because St. Eve was an appointment to the Court of Appeals by Trump in his first term. Yet, St. Eve was most recently on the Viramontes panel, and she was on an earlier case called Wilson. Wilson was another attempt by ISRA and SAF to get a semi-auto case in front of the Supreme Court. So Wilson was argued April 4th of 2019. It was decided August 29th, 2019. The panel there was Ripple, Hamilton, and St. Eve. And they came out with a 3-judge opinion. The first thing was they felt they were bound by Friedman. But the rationale that the court went on to extol here, I'm just going to give you a couple of tidbits. The district court dismissed the plaintiff's complaint on the basis of Friedman. We agree with the district court that Friedman is controlling because the plaintiffs have not come forward with a compelling reason to revisit our previous decision. We affirm the judgment of the district court. So there you go. Friedman, and if you saw Easterbrook and Wood in the Beavis opinion out of Naperville, they claim that despite New York State Rifle and Pistol Association, that Friedman is still controlling. This is the big hurdle, the big problem we have to get to. Now, let's run through the bingo card that is the gun cases in the Seventh Circuit. So first off, they have sat there and said they're not tying us to the other cases. So you have a case up in the Western Division called Keneally that is the former state's attorney up there challenging, I think it's the state's attorney in McHenry County, challenging the ban on his own. Okay, that case is pending out there. It's been held in abeyance pending everything else. You then have the Beavis case out of Naperville. So back in November, there was an entry in front of Judge Kendall on the Naperville case. And what they're saying is disclosures shall be exchanged by December 1st of 2024. End of fact discovery ordered by April 30th of 2025. Status hearing May 7th, 2025. Expert disclosures due by May 16th, 2025. Response expert disclosures by June 13th of 2025. And final depositions on experts by August 31st, 2025. So the Naperville case is run all the way out into August of 2025 under its present schedule. Let's click over to Herrera, which was the one that challenged Cook, the state, and Chicago's gun bans all at the same time, which was a ridiculous play and just caused us problems. So back in October, they said that first disclosures were due by October 29th, 2024. Then they've got first discovery by November 12th, 2024. The completion of discovery by February 26th, 2025. Joint status in February of 2025. So they're pushed out till the first the first quarter of 2025. In the order that came down from the Court of Appeals, they're not tying us to these cases, so we're not held in abeyance waiting for them, which could be up to August of next year. Now, you had Viramontes, which was argued a month ago, And the short orals there seem to be hostile to our side because the judges just picked up on what they thought was a lack of a record. Now, plaintiff's attorneys said, hey, it's in there, it's in our pleadings, but the judges just, they didn't think it was a thick enough record. Now, Sykes, the chief judge of the Seventh Circuit, was on that panel. Sykes was also on a case called Atkinson. Atkinson is a case involving a nonviolent felon trying to regain his rights, and the government saying, nope, you're a convicted felon. And in that, in the orals, they all but pleaded with the Department of Justice lawyer, hey, why don't you ask for more time? The record's kind of thin on this. We need to develop this. And he just said, no, we think it's all in the record. And they ended up remanding that case to build a better record. So we have a couple of problems here. One, if they make a decision on Viramontes, if they don't include a carve out that says another case could come back with a fuller record, more complete record, and that could change our outcome, that this really isn't controlling, this is only based upon the record in front of us in Viramontes. They could remand Viramontes for, hey, we want a better record. They noted in the oral arguments the record that was developed in Barnett and the Southern Illinois consolidated cases. They are well aware of this. So I hope that we don't. I think Easterbrook is going to be chomping at the bit in the short term to triple down on the frivolous ruling of Friedman and try to just throw another plant another flag on the field, daring Clarence Thomas. Now, let's jump up to Clarence Thomas in the Supreme Court. The good news for us is the Maryland case, formerly called Bianchi, now called Snope, is pending review by the conference. So it's been distributed for conference. They will take it up a week from today on the 13th of December, and we'll find out. Now, they normally release orders on Mondays. And so Monday the 16th, we could find out, one, they're denying cert. Two, they're accepting cert. Three, they're going to relist it. I hope they don't relist it. I hope they just take it. If they just take the case, I think then our case will be put in abeyance and paused until the Supreme Court rules in the Snope case, Maryland. I just don't. I could see Easterbrook's ego wanting to say something. My fear, I think the Supreme Court needs to take this unless they think there's such a record in our case that they're going to wait. But that's going to push us into the 2025-2026 term if they're waiting on ours. I have a few thoughts about what needs to be done because of St. Eve. And as we're knocking on 15 minutes here, I will do an entire video on the Wilson case and the comments in there and other things that St. Eve has done in a couple of these cases. Either she is playing it right down the line by the book, saying that my hands are tied by prior precedent, and here's what there is. Now, between New York, which Easterbrook is just casting aside, and the record that is built here, there's a chance for her to go a different way. I know other people are banking on that, they're betting on that, or they're at least hedging towards that. I'm not so convinced. But it is, the stay was not unexpected. Bill Kirk over at Washington Gun Law completely was right, and I agreed with him that it was going to be win, stay, we'll probably lose, but I'll do another video on how I think we need to attack some of this to get our points across and all that. So, as always, guys, from the frozen tundra of northern Illinois, it is a sweltering 13 degrees out this morning. I wanted to drop this out there. Sorry I've been remiss in not putting more content out. However, I'm hoping to correct some of that. We were on a trip and just trying to take care of some medical issues here at the house, getting Amy through all her checkups. She is doing well. She's doing better. She's going up and down the stairs. and slowly regaining her strength and everything else. So thank you for all the well wishes. I really appreciate it. And a quick hat tip out to MMI, pun intended, for the neat cap that they sent up to me. And if you're down in that area, Manuka, they're a nice little gun shop to sit there and stop in, visit, chat with the guys. They really are some great guys. So as always, we appreciate it. Please like, subscribe, copy, paste, send the link around to your social media stuff. And as always, frag out.